General Clement.
Mr. Chief Justice, and may it please the Court, appellant's claim here is an odd sort of First Amendment complaint. He does not suggest that Section 319 has limited his own spending at all. In fact, he has twice spent a substantial amount of his own money in excess of the statutory triggers.
He claims that it has penalized his own spending.
Well, and we can talk about that as well, but I think it's worth recognizing that his own spending is unlimited, both in theory and in fact. And if anything, he's announced his intent this next time around to spend even more of his own money. And the other thing that I think is relevant is his experience is not atypical in this regard.
That just means he's willing to accept the penalty in the next election, even if this case doesn't come out in his favor.
Well, Justice,
it doesn't prove that it isn't a penalty.
Well, I don't think in any way it's a penalty, and I think in order to understand it as a penalty, you have to accept the proposition that you start out with a constitutional entitlement to speak freely without the opportunity for the other side to respond. And I don't think the Constitution recognizes this. This isn't a context where they forced the appellant to pay for the other side's speech, as in Tornillo, or carry the speech, as in PG&E. And I don't think it's fair to look at the record here and suggest that what Congress was trying to do here was actually limit or deter self-financing.
Isn't there something very strange about having different contribution limits for candidates in an election? Do you think it would be constitutional for Congress to say that the contribution limits for incumbents is X, but for challengers it's 2X or 1/2 X?
Well, I think 2X would be constitutional, and I think most people would be surprised that Congress passed a statute that gave more generous contribution limits to challengers, but I think it would be a perfectly appropriate regime because it would recognize that incumbents have certain built-in advantages such that the relatively low hard money contribution caps have a greater influence, greater impact.
You think that's really a proper function of government, to look out over there and say we're going to even the playing field in this election? Well, what if one candidate is more eloquent than the other one? You make him talk with pebbles in his mouth, or what?
No, Justice Scalia, I think there's an important distinction that was suggested in one of Justice Alito's questions between the government trying to level the playing field in the abstract and the government looking out not at the eloquence of candidates, but at its own campaign finance regime after this Court's decision, and recognizing that, look, the differential...
The campaign finance regimes we've approved up to now, the significant limitations, have had an anti-corruption rationale. There is no anti-corruption rationale here. The only purpose of this is to level the playing field, and I am deeply suspicious of allowing elections to be conducted under a regime whereby Congress levels the playing field. That seems to be very dangerous.
Well, again, Justice Scalia, though, you start with the anti-corruption rationale that underlies the hard money contribution caps. And what Congress has recognized is that after Buckley and after this Court said that a candidate's ability to self-finance is unlimited, it's recognized that in a subset of elections where somebody is going to spend an awful lot of their own money to self-finance, the ordinary hard money contribution caps are going to have a potentially skewing effect.